Well, good morning, Mr. to this evidence session, and thank you very much for your written submission. I should start by apologising to you because we misspelt your name in the official earlier papers, but we've now corrected it on the website. And secondly, I should remind you, as you're undoubtedly aware, the proceedings are recorded, broadcast on the Parliamentary site and transcribed by Hansard. Could I start by with a general question? The reason that the primary legislation was preferred to voluntary codes of practice or government regulations was to provide again the prospect of redress against bad practice, but we've heard a lot of evidence, or we've heard evidence, that the law is frequently not complied with and non-compliance is rarely prosecuted. Has the use of the statute proved as effective as was expected in changing the practice?
May I first say that I've got a cold coming on, so if I'm snuffling at any stage or my voice goes, that's the reason. I really don't think I'm necessarily the right person to speak to this because my main role is as litigation friend when proceedings have commenced. So I'm not there in the background in the first instance. Having said that, the section, the criminal offence, only relates to ill-treating or willfully neglecting the person without capacity and doesn't go to whether or not decision-making is properly in accordance with the Act and the Code of Practice. So that's not really answering your question, but I think that's the best answer I can give.
Yeah. Well, could I then ask a slightly different question, which may come within your experience? Since the passing of the Act, has the case law differed significantly as a result of the Act than the approach adopted prior to the Act?
Well, I think that in relation to property and affairs applications, although the test is now best interests, whereas before it was to a large extent substituted judgment, really the outcome is the same in relation to property and affairs applications. I've currently got about 378 of those on. In relation to the welfare cases, or the healthcare and welfare cases, there has been an enormous increase in the number of those. I've just got some figures which I will be able to hand to relevant clerks in due course, but by April 2008, which was 3-4 months after the coming into force of the Act, I had 42 welfare applications on the books. As at the 1st of October the previous year, 2007, I had about 70 odd, and I currently have 527. And that has gone up April on April. So April 09, 216, April 10, 368, April 11, 438, April 12, 601, and although we have put away some cases, and that reduces the numbers of finished cases, it's down to 527 this April. So the issues being determined by the court are much more diverse than the issues being determined under the inherent jurisdiction by the Family Division before the coming into force of the 2005 Act.
You mentioned inherent jurisdiction. Was the Act intended to remove that, or do you think the inherent jurisdiction should still exist in such cases?
Well, the judges certainly have held that the inherent jurisdiction still exists to fill any gaps left by the 2005 Act. And I think I mentioned in my written response the case of A, who was the hunger striker from Iran, and because of the effect of the labyrinthine Schedule 1A, and the fact that the treatment to be given for him did not fall within the Mental Health Act, there was a problem in that his liberty could not be deprived in order to give him the relevant treatment under the Mental Health Act or under the Mental Capacity Act. So Mr. Justice Baker held that he could deprive A of his liberty so that he could be given the treatment under the inherent jurisdiction. And Mr. Justice Cobb had done something similar, but rather more summarily, the previous week, and it's undoubtedly the case that the Court of Appeal has held on a number of occasions that the inherent jurisdiction remains.
Thank you very much, Lashman.
Thank you. You identify, Mr. Pitbladder, in your submission that the current interpretation of a deprivation of liberty is a narrow one, and many other submissions to the inquiry have asked for a statutory definition. Is such clarification possible and necessary, and would it address the concerns raised in your submission?
I don't think it's either possible. I don't think it's possible. Therefore, one doesn't need to carry on and consider the second question. And the reason I don't think it's possible is because the question of whether or not a person is deprived of their liberty is a question which relates to Article 5 of the Convention. And so long as Article 5 remains in force in this country by virtue of the Human Rights Act, the interpretation of Article 5 by the European Court of Human Rights is the relevant interpretation. So the referential definition in the Mental Capacity Act, Section 65, I believe, is the only correct one. I say that having been an advisory lawyer in government departments for 20-odd years before I was appointed as official solicitor, so I did have some experience of primary legislation, lots of experience of secondary legislation. I think one of the problems with the effect of the two judgments of the Court of Appeal is that it doesn't feel right to the people on the ground that the definition is so narrow. We haven't yet had the judgment of the Supreme Court in those two cases. We're waiting anxiously to get the judgment or judgments. And it may be said, if the arguments that were being put forward on my instructions are accepted by the Supreme Court, that the definition is too wide. But I think that the current effect of the judgments of the Court of Appeal, are that very few people are being deprived of their liberty who are not free to go. Now, of course, what being not free to go means is open to debate. And the question is, if somebody is acquiescent, and the European Court of Human Rights has held that acquiescence is not the touchstone, not the bright line, if a person actually, in reality, has to be looked after, then are they free to go or not free to go? But we will see what the Supreme Court rules.
Yes, can I just ask you a bit more about that last answer? You quite rightly referred us to Article 5 and the fact that it is the Strasbourg Court which gives us guidance as to what constitutes a breach of a convention right. I mean, the convention is a living instrument. So does it follow, really, that we can't freeze the definition of a deprivation of liberty because it will be subject in any event to developments in the Strasbourg Court?
That was what I was trying to say.
Yes. The next question, to some extent, you've already dealt with, which is the problem about the hunger striker and the so-called new Bournemouth gap. The court decided it on the basis of inherent jurisdiction. Is that satisfactory, or do you think that we ought to be advising some legislative change to fill the gap?
Ideally, I think that Schedule 1A should be looked at so that it allows the Court of Protection to deprive P, the relevant person, of their liberty for the reasons that Mr. Justice Baker made the order which he did. I think, although there is, I believe, a more recent consideration and a judgment in the upper tribunal by Mr. Justice Charles of the interplay between Schedule 1A and the Mental Health Act, nevertheless, it appears possible that Schedule 1A is too tightly drafted and excludes the sort of case, unusual case, where the treatment doesn't fall within the scope of the Mental Health Act, where there is a deprivation of the liberty, and sometimes a double deprivation of liberty, because even when somebody is deprived of their liberty, they can nevertheless be further deprived of their liberty. Somebody in an ordinary prison is put into solitary confinement or so on. And in that case, although by the time of the judgment, Dr. A was sectioned under the Mental Health Act, nevertheless, the treatment he was going to be given involved a further deprivation of his liberty. I know this all sounds very arcane, but so I think there might be scope for loosening up the provisions of Schedule 1A. Thank you.
Yes.
But just listening to you and not being a lawyer, I'm trying to get a hold of this, because it seems like obviously a rare but significant issue, this. Is it, in your view, a deficiency, if a deficiency there be, in the Mental Capacity Act that opens up this gap? Or is it, in fact, a shortcoming of the Mental Health Act? I mean, that's what it's very hard for a non-lawyer and a non-practitioner to get a handle on. And in a way, I feel quite surprised that somebody who's detained under the Mental Health Act in the way that this person was, the Mental Health Act is so prescriptive about what may or may not be offered as treatment. Is that an issue in your view?
Well, I'm not an expert on the Mental Health Act. I consider it from time to time when it is involved in cases where I'm acting as litigation friend in the Court of Protection under the Mental Capacity Act. I would not be suggesting that the Mental Health Act requires amendment, because the treatment that can be given under the Mental Health Act is quite wide, but it must be treatment for the mental illness, and that's well established. I think the problem in this case, and in any similar case, is that Schedule 1A of the Mental Capacity Act, which was inserted by way of amendment into that Act, is just a little bit too tight and excludes under the eligibility requirement persons who need the assistance of the Court of Protection. So I think it's the Schedule 1A that could be and should be, if possible.
Thank you.
Sorry?
Thank you. Apart from Schedule 1A, which you've just elaborated on, are there sufficient protections in the Mental Capacity Act, the Court of Protection and the Office of the Public Guardian to protect those who lack capacity against abuse, whether it's financial or otherwise? Are there any other gaps that you can see, now the legislation has been in place for some time, that perhaps we should be alerted to?
Well, I've asked my property and affairs lawyers particularly about this question, and what they told me, and I'm sure it's correct, because I don't actually focus as much on that area as on the welfare side, is that since the implementation of the Mental Capacity Act, there's been greater scope for property and affairs deputies, previously receivers, to use P's funds without authority, either through ignorance or intention. Under the old Mental Health Act regime, receivers only had access to income and not to capital. If they wished to apply P's capital, they needed prior authority of the court, and that was actually obtained quite without a great deal of process. But now the order appointing deputies provides wide general powers. I won't read them out. I know that the Office of the Public Guardian has been providing new written guidance to deputies as to what gifts can be made, and that's backed up by the Code of Practice at Chapter 8. But the deputyship order is drafted in such a way that lay deputies quite often consider that they can do what they want with P's money, even to the extent of paying it to themselves or to members of their family. And there have been 3 recent cases, I think, which I imagine the Public Guardian will be telling you about, because he was instrumental in bringing those cases where the Court of Protection had to look at funds being siphoned off to the wrong place. So I think that some of it is, in answer to your question, I mean, some of it is how people behave out there, as it were, in the real world when they have the powers of a deputyship. And as I said earlier, it might be ignorance, it might be criminality that is involved, but it was much tighter before. I think the rest of the answer must probably come from the Public Guardian. In terms of protection of people in respect of their welfare decisions, I think undoubtedly the Act has produced greater protection and a greater emphasis on the rights of those who lack capacity and on proper decision making and on trying to take into account their wishes and feelings and so on, so that I think there's been an upside on the welfare.
Thank you. Could I just come back to this question of property, and in that sense something quite material such as a residence, say. I don't want to get too much into the legal aid question because I think you're going to get a question on that later. But I noticed in your evidence you said that where somebody retains a property, a dwelling house is specifically mentioned, then you have to withdraw as a litigation friend because they are deemed then to have this asset which can't be liquidated. Is that correct?
No, I probably didn't explain myself very well. My predecessor had more money in his budget for various reasons. And the office was in the practice of saying, well, we'll fund this litigation out of the budget when we have a crystallised sum of money. In other words, the costs have been assessed, we'll place a charge against the property, and then in due course when the property is sold, we will recover the costs. Well, I can't do that in this age of austerity. So what I was trying to say was that if I worked on that basis, that I was going to get my money out of the house as and when sold, the relatives, and I'm postulating a case where the relatives are saying mother, father, whoever should come home, would be saying, and if I took the view on the basis of the evidence that it was in the best interests for mother or father to stay in a care home or nursing home, then the relatives would be saying, oh, well, you've got a financial interest in getting this property sold as soon as possible.
Yes.
So that's just a presentational issue. It's not a sort of a legal issue.
Right.
And I mean, although it would not be affecting my mind, I could see how people would suggest and could even think that it was affecting my mind as to the best interests of P. So that's what I was trying to say.
I see.
There.
No, thank you very much.
Could I go back to section 44, which we touched on earlier, and you very properly pointed out that this was an offence of ill treatment of someone who lacks capacity. Now, there has been judicial criticism of the terms of the section because it lacks the clarity, as some judges say, which one might expect, or which is entitled to expect of a criminal offence. Do you have any views about that?
No.
Yeah.
Well, I'm not I don't get involved in criminal cases.
No, I just wondered from your drafting experience, whether you consider it might be redrafted.
I was just a humble departmental legal advisor, so I wasn't
Yes.
parliamentary counsel.
Well, as Lord Advocate, I had many humble departmental legal advisors who were very good at drafting and knew more about it than the Minister, but thank you very much. Lydia Hollands?
You said at the beginning that as a litigation friend, once proceedings have commenced, you're not involved in the background, so I don't know what your response will be to this question, but how do people find out about the services of the official solicitor? Are you confident that those who need and are eligible for your help are able to access it? And is representation often refused because of a lack of legal aid or a lack of capacity in your services?
Well, to answer the second question first, it is a problem for me, my office, and it is one of the reasons why sometimes there is a delay in my accepting cases, or sometimes I have to refuse to accept cases if there is no funding, because medical cases apart, where traditionally I and my predecessors have always funded the litigation out of our budgets, subject to seeking to recover half the costs from the hospital, which is gaining an advantage. I need money to pay the outside solicitors. I must instruct outside solicitors because I couldn't do all the legal work in-house, so I don't have enough lawyers. And really the question about people ending up with me as their litigation friend is really the other way around. It's normally a public body will issue proceedings. The person concerned will be made a party, which I'm not sure which I think is more frequent than the policymakers might have expected before the Act was brought into force or was enacted. The court will make P a party, and P therefore requires a litigation friend. If there is no family member or anybody else who is suitable and willing, then they always look to me. And quite often the family are not suitable. They may be willing but not suitable because the dispute that has caused the proceedings to start is between the family and the public body, and therefore they cannot act as litigation friend without an adverse interest, because they have their views about what's in the best interest of their relative, which may of course all get mixed up with their antagonism towards the public body and vice versa. Well, I won't say that public bodies are antagonistic towards relatives, but sometimes there is an unfortunate clash. So it isn't a question of the family thinking, oh, we need help, we'll get the official solicitor involved, and it's certainly not a case of P thinking, I need the official solicitor, I need a litigation friend. Who might it be? Oh, the official solicitor does that. It's normally the court, especially in the Court of Protection.
Okay. We've had evidence that obtaining expert reports can delay can add significantly to costs and delays. Mm-hmm. Do you agree with that? And if so, what solution would you recommend?
Well, I'm in favour of obtaining expert reports because neither I nor my staff nor the solicitors I retain on behalf of P are expert social workers. We are not experts in the creation of care plans, in the assessment of whether a care plan is a good care plan, in whether or not it is safe for the person to go home. If they do go home, what adjustments are necessary to enable them to go home, whether care home A is good enough, care home B is not good enough, all those issues. So I don't think that where one is having a proper assessment of best interests in the context of making a decision on behalf of a person who lacks capacity, that you can do without experts. Not in every case, but very often you can't. Section 49 permits the court to ask either a local authority or the public guardian or the office of the public guardian to have instruct an expert to report. Some judges prefer independent experts if they're going to have experts. Others are content with Section 49 reports. But I particularly raise that in the context of Section 21A, which is when somebody is deprived of their liberty under a standard authorisation. And I was describing that process. Generally, yes, it does increase costs, and I would not be asking for experts unless I thought it was appropriate in that case and necessary for the for me properly to represent P.
That leads on to my last question, which is about whether the official solicitor has the requisite skills to support individuals with significant communication needs. And I mean, it may be that you've already answered that by saying that your staff don't have all the skills necessary to make a proper assessment of best interests.
Well, I think that's correct. We're litigation friends. That's the service I provide. And if a person has communication difficulties, then we ensure that that factor is taken into account, and that somebody, an appropriate specialist, is instructed to enable the person to communicate. A person who can communicate with deaf people, a person who, I mean, sometimes it's a question of having to have a translator and interpreter. Sometimes it's so that's why we look for experts and the right experts to do the entire job. It wouldn't be feasible, I would suggest, for my office to be filled with all the relevant experts who could deal with any given set of facts, as it were.
But it leads to additional cost and delays. Is there a solution to this?
I can't see that there is one. If P is to be properly represented, and one isn't simply going to say, well, whatever the social workers say is correct, and one has to communicate with P to the greatest possible extent and try and find out as best as we can their wishes and feelings, their beliefs and values, and any other factor which they could be expected to take into account, then we must be able to communicate with them, not directly, but through the assistance of an appropriate expert.
Thank you.
I was just wondering, Mr. Pitbaro, whether the changes in legal aid in general have had an impact on the work.
Well, I have been being told by my staff, and I have no reason to doubt it, ever since I was appointed, which was 7 years ago, and I'm thinking more about family cases. When I was a young barrister, dwelling homes were excluded from the calculation. Then there was a disregard for the first 100,000. Well, there aren't that many dwelling houses, certainly in most parts of the country, where that doesn't have an adverse effect on eligibility for legal aid. I mentioned, I think, in my written response, the passporting issue.
Yes, indeed.
undoubtedly the quality of some solicitors, not on the whole the ones I use in the Court of Protection, because I have a pool of solicitors I use. I'm prepared to obviously to expand that, but they do it because they want to do it. They regard it as work that redounds to their credit, as well as making money out of it. So yes, it does make life more difficult, because sometimes, as I said, if P is an elderly person with a dwelling house who's been taken into a care home, then they're probably not entitled to legal aid, and that causes great difficulties.
Thank you very much.
Maybe a bit obtuse, but is it true that you have had to refuse representation of people because they lack legal aid, because of lack of legal aid?
Yeah.
So it's entirely a funding issue.
Yes. I mean, occasionally people have a lot of spare liquid capital, not very often. And in those cases, and they will normally then have a deputy, if they do, or will be getting a deputy. If they lack financial capacity, and of course every decision, not each and every decision, but every class of decisions, a person may or may not have capacity in relation to that class, although some classes have easy instances and difficult instances, like medical decisions. Shall I have a flu jab? It's a fairly straightforward decision. Shall I have a complicated brain operation? A difficult one, which requires a lot of assessment of risk and understanding what the doctors are saying to you. So if the person may lack litigation capacity but have financial capacity, I know that sounds odd, but assuming they don't have financial capacity, I get an order from the court enabling me, if there is money to pay the costs, to get it from them. In the same way that a sort of middle-income person in any normal form of litigation will not be entitled to legal aid and will have to fund it themselves, which they may well find very, very difficult if their main asset is their home. So it's not that it's not different in that sense, but it does cause me quite a lot of difficulty, and some of my staff spend a lot of their time trying to work out how to fund the representation of the person I've been asked to act as litigation friend for.
If the dwelling of P is held in a trust for the lifetime interest of P, I assume then that dwelling doesn't come into the equation in terms of looking at their assets.
I have to pass on that one. I do know that in relation to paying for care, that if there is a discretionary trust which was put in place early enough so that it's not a device once capacity is lost to avoid paying the care home fees, then that does work. But it is a question of making sure, it's a bit like inheritance tax avoidance, by making gifts 7 years before death.
Yes.
If you actually do it and divest yourself of your asset when you have capacity to do so, then I think it would work. But then lots of people are quite reluctant to divest themselves of their capital in order to avoid, so that their children can avoid inheritance tax.
Yes, thank you.
Ms. McIntosh?
Well, I think actually we've sort of covered what's in this question, but can I just explore with you a little bit more this issue about the relationship between people's desire to access your services and the things that might impede them from doing so? It sounds to me as though fundamentally the issue is money, that they either have it, in which case they can choose to spend it with you, or those who act on their behalf can choose to spend it with you in litigation, or they are eligible for legal aid, in which case the problem is solved that way. But are there other things which would discourage people from coming to you, other than not being able to pay for your services, as it were?
Well, I think I need to emphasise that most of the people lacking capacity for whom I act as litigation friend have not come to me. Sometimes they resent the fact that they have a litigation friend, and it is primarily the court which will invite me to act as litigation friend. And the main impediment is funding. Sometimes people will assert their own capacity. They will say, I've got capacity. They will do that both in the civil courts, the family courts, and in the Court of Protection. The rules provide that if a person may lack capacity, the proceeding can start. Litigation capacity in the civil courts, the other civil courts, has to be assessed before they are treated as a protected party and require a litigation friend. So there's a bit of after the event assessment that goes on in the Court of Protection, which is fine because people who do lack capacity need protecting. So that's the main problem is sometimes assessing capacity if a person's unwilling to be assessed, but the main problem is money.
So, in your view, is the Court of Protection, at the moment it seems to be the only route whereby these issues can be resolved when they reach a critical point, but can you imagine any other route which would avoid all the, sorry to use the word, but the paraphernalia of court proceedings followed then by further court proceedings? Is there another way in which some of these matters could be resolved?
Well, sometimes when it's distrust between P's family and the public body, there must be scope for getting them round the table. Certainly in my property and affairs cases, my lawyers who case manage those will chair meetings between the various family members who have an interest in the subject of the application to try and narrow issues. I have had serious medical treatment cases where usually a case of a catastrophic accident, catastrophic injuries, one young man who was shot in the head, his family desperately wanted him treated, the clinician said it was futile and burdensome. I had an intensivist go in because there were court proceedings, and he was able to, and he's done it in other cases, he was able to persuade the family that really there wasn't a great deal that could be done, and then he persuaded the clinicians to do a bit more than they were proposing to do, and he was able to mediate between them. And I'm sure that sometimes families and local authorities could be got together.
May I just interrupt you? It was very interesting, and I'm sure it's going to go on to be more interesting, but can I just stop you on that particular issue, the case you've just described? There are costs involved in your lawyers convening those discussions and then the subsequent interaction with the clinician and so on. Who meets those costs and from what budget?
If we're talking about the property and affairs cases, P.
So that you might set up a sort of quasi-mediation or an informal mediation procedure for which costs are incurred, and those costs would fall on P?
In property and affairs, all the costs fall on P, usually.
By whatever means, yes.
Person makes an application, they will normally get the costs out of P's estate. I'm appointed to act as litigation friend and solicitor for P. I get my costs out of P's estate.
But the medical issues are different.
In the medical cases, the costs of the trust, I keep thinking of them as trusts, I know that they're now different, but the costs of the hospital will be met by themselves. Normally the family won't be represented. because very often the family aren't entitled to legal aid, and in any event, events are happening so quickly that they will simply be at the hospital talking to the clinicians. Maybe the clinicians are not the best, don't have the best bedside manner, maybe the family's very demanding, maybe there's just a sort of mixture of it, all of that. I will be paying for the expert, the intensivist, or whoever I've asked at a very short notice to go in. In due course I'll be paying for counsel, and then I will seek half of my costs from the hospital.
Sorry if I just pursue this just a little bit further. The budget to which you referred earlier in one of your earlier answers, which has been, as you implied, significantly reduced.
No, it hasn't. I didn't say that.
Or there are greater calls upon it, perhaps.
Yes.
Right. Either way, it doesn't go so far as per individual case as once it did.
No,
Would that be right?
You're correct. 10 years ago, my predecessor had money coming in from various sources that he then redistributed in various ways within his budget. I don't have that anymore, and although my budget hasn't been cut, the Ministry of Justice has been mindful of the work I do. I nevertheless have no spare budget to fund things that I didn't used to fund.
But the budget that you do have would be available to you at your discretion, this is a question, to deploy in cases such as the one you've just described, where there was an immediate need for some legal intervention to break a deadlock or settle an issue that was of needed immediate attention, such as somebody having suffered a catastrophic injury, as you described. And that fund exists and you are able to access it at your own discretion, is that correct?
Yes. To pay the experts I am advised and I personally think are necessary, and counsel. I'm acting as solicitor in those cases. Yeah.
Okay. Thank you. That's very helpful.
That case that you just explained to Baroness McIntosh, and also cases where you say in property and affairs where the family get together and there's some form of mediation. If it's successful, the ultimate benefit is that the case doesn't go down the route of the Court of Protection, and the costs of that are saved. Is that correct?
Well, invariably in all these cases, there has been an application to the Court of Protection. So the application's been issued, the fee for that has been spent. In the property and affairs cases, it will be a family member who will want either a statutory will approved or a variation of some settlement. And in the medical cases, it's almost invariably the trust that has brought the proceedings, so that it gets its back covered in relation to the treatment that it probably doesn't want to give in those sorts of cases. So there are proceedings. I've been invited to be litigation friend. Usually in those cases I've accepted, because in the one case, in the property and affairs cases, there won't be an application unless there's some money, out of which everybody gets their costs, whether that's right or wrong, that's the rule. And in the medical cases, I have a budget for that purpose.
So will there be a benefit? The proceedings won't, although they exist, they won't be as protracted as they would otherwise have been, thereby saving the system, have I put it that
Certainly,
way?
Yes. I mean, sometimes there'll be a consent order or a withdrawal, or normally in the property and affairs cases there'll be an agreed order that's put to the judge, and the judge will look at it and read the report that I put in and approve it or not. Usually approve it. In the medical cases, it may well be that there is really practically no dispute left.
Baroness Barker?
Explained to us this morning the different ways in which your office either can bring about mediation or by using experts and expert witnesses ascertain the wishes and feelings of P. How often does it appear that these have a decisive impact on the outcome of cases?
Now, when I hand my written speaking notes into the clerk, there will be a written answer to this. I mean, my first point about that is that the policy behind the Act is that decisions must be made in best interest rather than substituted judgment. Yes. If one looks at Section 4, the primary provision is Section 4.2, which says that the person making the determination as to best interest must consider all the relevant circumstances and in particular take the following steps. And then there are the number of steps, including 4.6, which talks about the wishes and feelings, past and present, beliefs and values, and any other factors, and 4.7, which requires the decision maker to take account of what the family believe the wishes and feelings were and would be, beliefs and values and so on, and also what they think is in the best interests of P. So, yes, those are important factors. I know that sometimes it's called the Section 4 checklist. I think it's not really a checklist because you start off with 4.2 as needing to consider all the relevant circumstances, and that's defined in 4.11, what that means. So I think sometimes it's quite important. Certainly in deprivation of liberty cases, there has been a tendency to consider very carefully what the person's wishes and feelings are if they're saying they want to go home. I mentioned a case in my written answers, 3 directions hearings, 6 days of argument. The P, she refused to unpack her bag despite having been in the care home for months. She said she was a prisoner. The 2 Court of Protection visitors both said she could go home with a little bit of tweaking in her home. I was arguing that she should go home. This particular judge made this decision that she shouldn't go home, that she should actually go to a different care home in a part of the country she didn't want to be in, near her family. Well, she didn't particularly want to be near them as far as we could work out. Having said that, I mean, that was the judge's decision.
She sounds a wonderful woman.
The president famously said in one of his judgments, you know, what's the point of making people safe if they're miserable? The judge, in the case I've just been describing, was clearly much more risk averse. And at one stage asked, well, what would I do if it was my mother? Well, if it was my mother, I'd send her home. But, I mean, clearly, if it was his mother, he wouldn't. Wishes and feelings, yes, they are taken into account, but they're not necessarily determinative.
Throughout our hearings, we've talked to different people from different professions about the balance between best interests and safeguardings, and there's a clear perception out there that amongst different professions approach the Act and use it in different ways. So it's interesting to see where the court takes that. But can I ask you, because of that, how frequently do the people actually appear in the court proceedings, and does that make a difference, given that the court as yet only doesn't yet sit regionally and so on?
Well, it does sit regionally, but not as much as it could.
Good, yeah.
And certainly that all the family division judges of the High Court will sit in Newcastle and Birmingham and Leeds and Sheffield and Liverpool and Mould and down in the West Country, in the county courts in the West Country. But I think what the President is going to try and do is have less cases heard by High Court judges and more cases heard by the circuit judges who have the ticket and the district judges who are already doing so. I've now forgotten the question. Sorry.
How often do the people take part
in
proceedings,
yes.
or is it just in the nature of
well, I think originally, and certainly under the inherent jurisdiction, although there were cases under the inherent jurisdiction when the judge would see and talk to the person in respect of whom the decision was being made, and there was a very famous, in my world, case where Dame Elizabeth Butler-Sloss went into a hospital bed and spoke to the person concerned and satisfied herself that the person concerned did not want to be treated, and made a decision that she shouldn't be treated, and she was allowed to die. That is happening more and more in the Court of Protection. I don't mean people being allowed to die, but the judge is actually seeing P, and I've certainly got it on my agenda to try and facilitate it wherever that's feasible.
Thank you.
Is technology used, remote links?
Yes, sometimes, yes.
Yes. Barbara Sanders?
I think you have answered this question, actually, but let me put it to you this way. We've had quite a lot of evidence that people are concerned about what they see as delays in the system, particularly around the financial property areas. You've already spoken about the huge increase in workload, about tenfold increase, and about the constraining effect of costs. Do you think that the complaint about delay is a matter of perception, given the complexity of the issues that you're dealing with, or do you think these are real issues to do with processes above and beyond these two major issues of workload and costs, massive though they are?
Now, I'm assured that the property and affairs cases that I deal with aren't taking longer than they used to in the old Court of Protection. I can't speak about some of the newer areas that are dealt with by the Court of Protection, but the statutory wills and settlements being varied and gifts being made by application to the court, those, I'm assured, are really not taking any longer. I think there was, and I don't think the Court of Protection would hesitate to accept, when it was first came into being, there were delays that have now, on the whole, been remedied. Now, the outside perception of what is a delay that's been remedied, and the court's and the lawyer's perception, and the judge's perception of what's a delay that's been remedied are probably different. But any piece of litigation is going to take some time. So my answer in relation to property and affairs is I'm advised that those cases are not taking longer than they used to in 2005, 2004 and so on. There was a period where they were, and of course people remember that sort of thing, and it colours how they perceive the current process, even if the current process is more efficient. In relation to welfare cases, I try and get them finished as soon as I can. That's for pragmatic reasons of freeing up my case managers to manage other cases. It's because I don't like to have them hanging around. It's not good for P, it's not good for their families. The only people it's good for are the lawyers, and I'm not interested in their welfare. So I do try and get those cases sorted, and I don't like to have them hanging on simply because there's some issue which may or may not need considering in 6 months' time. Obviously, if you can't finish the case off, you can't. But that has a fairly broad spectrum of when you can finish a case off and when you can't finish a case off, because you can always think of what's going to be happening in 6 months, what will happen after P's been moved into supported living from the care home, and so on and so forth. I take the view that unless there is currently an issue to be determined, we should try and get the case finished. Not always successful in that, but I try.
On the business of comparison with the previous process, I can say that it's clearly to your credit that it's not taking any longer because circumstances have changed, as we've discussed anyway. But do you think is there an internal review or audit process which looks at the processes of the office? And is there any scope at all for shortening any of the processes, do you think, in an administrative sense?
I spend a part of my time trying to make sure that the case managers do an appropriate, put an appropriate level of effort into the case, and don't sort of gold-plate it, Rolls-Royce it. But that really is not a factor which leads to delay in the progress of the case. It's a factor which increases workload within the office. Although you could say, well, right, if they're increasing workload in the office, then the caseload won't be processed as quickly. I believe that the length a case takes will depend upon all the participants, from the court to the local authorities or hospital to the family. Yes, experts will add to the length of time, but as I said, I think they're necessary when I ask for them. So I do look at internal process, but I don't think that's really a factor in the overall delay in the case. I think it's more a question of internal stress and case managers having to do what's necessary rather than what they would possibly like to do.
Can I just, one final question. How much was your budget cut?
Sorry?
How much was your budget cut?
It hasn't been.
Oh.
No, I think that's been answered already. There hasn't been a budget cut at all. There's an issue about the workload, which is, Lord Swinfen, I think this question has really been dealt with already, hasn't it? Yes. Can we go on to Lord Foulkes?
You already mentioned the fact that the President, and in your written submissions, the President of the Family Division has made some suggestions for changes, including more use of circuit judges rather than High Court judges on circuit, which I think is the current arrangement. And they have to be ticketed, I think, before they can do that, and generally more publicity for hearings. Do you think that the suite of reforms that look likely are ones that are going to have a good impact, beneficial impact on users of the court?
I do. Taking, for example, the press being in court, which is the norm in the family courts. It's the reverse in the Court of Protection. I took 2 cases to the Court of Appeal in relation to P's privacy. There was, since then, there has been, I think, a clear set of rules that if the press apply to be allowed in, I never try to stop them going in on the basis that it's still in private, and then they ask the judge to allow them to report X, Y, and Z. I'm still concerned to protect P's anonymity, but I think it would be a lot easier if the press could go in without that process, because I just regard it as something which adds to the process, it adds to the costs of the press, it adds to the overall costs, and I don't really feel I need to be looking at that. So that will be helpful. It's very important that judgments are published, and I think they are largely now. One of the reasons for that is it's quite easy for disgruntled family members to distort the facts, as they do in care cases from time to time. And I think that if more and more cases are dealt with close to where the people live and where the local authority is, that will be only to everybody's benefit. And now that we've had a few years of jurisprudence, case decisions in relation to the issues that are dealt with by the Court of Protection, I can see no good reason why it has to be a High Court judge. So, yes, I think they will help. Whether they will, reduce the average time of a welfare case, and I don't know what the average time of a welfare case is, from just plucking figures out of the air, from 9 months to 6 months, I don't know. They might reduce it from 9 months to 8 months, but I think it will be beneficial. They will be beneficial.
I suppose you've got to make sure that there are judges who are appropriately trained, which involves costs, and there may be some reluctance to train up enough.
Well, next week I'm going to the Judicial College to speak to judges who are being ticketed. Of course, when I was a young man, a circuit judge did crime, family and civil, but that's apparently no good anymore.
No.
Well, thank you very much indeed, Mr. Barrow. We're very grateful to you for your evidence, and it's been a very full session, and we'll now move on to the next evidence session.
Thank you. I'm very pleased to have been able to offer some assistance.
Good morning.
Morning, Mr. Eccleston. Welcome to this second evidence session this morning. We're grateful to you for your written submission, and I have to remind you that the proceedings are being broadcast internally and also recorded and transcribed. Could I start by saying asking you what impact the creation of the statutory role of public guardian has had in practice?
Yes, good morning. Good, and my Lord Chairman, in relation to that question, I think the creation of this statutory role for the first time by the Act has given a real clear focus to the primary responsibilities of the office, which are around the registration of lasting powers of attorney, the supervision of court-appointed deputies, and the safeguarding investigatory function that we undertake. And I think that focus is evidenced by the fact that year on year, the Office of the Public Guardian has seen a significant increase in the workload that's come into the office, which means that both knowledge of the functions of the office and indeed demand for the services that we offer are growing significantly.
Thank you. Lord Turnbull.
The government is consulting on changes to the Office of Public Guardian. Can you give us any hint about what those changes might entail and what they might mean for the...
Yes, we're currently consulting on really four main areas. The first area is about trying to simplify the application forms for lasting powers of attorney. I think there's been an ongoing conversation, debate about how straightforward they are. On the 1st of July, we launched an online digital tool to assist people in the completion of a lasting power of attorney, and during that process we did a lot of customer insight work with applicants who were applying, and out of our learning from that we took the opportunity to review the forms. As you're aware, all of the forms are prescribed forms, and therefore we're consulting about making them more simple, more accessible. Shorter. You'll be pleased to know that the online tool means you only have to put data in once, and it pre-populates all the bits where you need repeated bits of data, and it checks the validity of the information, so we've cut out a lot of the errors that are made by people if they use the online form. But we've learned lessons to make the form shorter, and also to try and make some of the language in the forms more accessible to lay people who are making the applications for themselves. We're also consulting about having a joint form, So you only have to fill in one application form if you want to make both a Property and Affairs and a Health and Welfare LPA, which again cuts down substantially the amount of information that you have to put on the form, and actually makes it far more straightforward if you want the same attorneys to act in both capacities. Secondly, we're consulting about, we have a desire to put our registers online so that they can be electronically searched over the internet. Obviously that would be of great benefit to professionals who could then gain access to see whether or not there's either a deputyship order or a lasting power of attorney in existence. But we're conscious that always, with the work we do, there's a balance between access and protection for the vulnerable. So one of the things we're consulting about is how much should be accessible in our register publicly, whether there should be intermediate tiers of access for professionals, what information should we make available, and how do we make that information secure for those sorts of searches. The third area that we're consulting about is we launched last year a fundamental review of supervision. The number of deputies we're supervising is growing 8% year on year. We're currently supervising 48,000 deputyship orders, and the growth of 8% year on year means we need a sustainable model of supervision to actually ensure that it's proportionate, but also that we are giving the safeguards that we need to do when we're seeing such a significant growth in numbers. And so we launched a fundamental review of the supervision regime to ensure that it was sustainable, proportionate, and met the safeguarding aims under the Act. And again, we are asking questions about that. And the final area that we're consulting about is we have an ambition to eventually enable you to apply for a lasting power of attorney completely online, and that we respond to you electronically. So we're consulting about the possibility of removing the concept of it being a deed and linked to wet signatures having to be in paper, and moving to a modern format of being able to deal with you in that way. But again, we're consulting about the balance between access and speedily getting your lasting power of attorney against the safeguards that need to be in place to make sure that it is a secure instrument to be used.
Thank you very much.
Just a point. People tend to move once they've produced the powers of attorney. Do you have national health numbers or national insurance numbers on the form so that they can be referred to that particular person?
No, we don't keep that information at the current moment, and there's a big debate under data protection that there isn't a legitimate need for us at the moment to hold that. So legally I've been advised that we shouldn't be keeping national insurance numbers at the current moment.
But if someone is elderly and goes to live with a relation, and the relation doesn't know that the power of attorney has been granted, how do they find out?
Well, they can make an application to us to search the register to find out where the register... Yes, we have a considerable number of applications. At the moment, it's a paper-based application. They ring up usually our contact centre and make a request for a level 1 search. But quite normally in our experience is that the lasting power of attorney or the deputyship, unless it's held by a professional, is usually held by a family member, and these things are well known within the family. And it's usually the family that is notifying us that the donor has moved, and then we update our records accordingly.
Thank you.
What's the timescale for this consultation process?
The consultation closes on the 26th of November. Then obviously we will be considering all the responses, and the hope is that we will publish the response to the consultation in the spring.
Thank you.
What have been the practical implications of the changes in governance that resulted from the abolition of the Public Guardian Board?
As you're well aware, the Public Guardian Board was created under the Act and was an advisory board to the Lord Chancellor and sat outside of the Office of the Public Guardian, and its role was to scrutinise the Public Guardian and how the Public Guardian undertook statutory duties. As a result of the board being abolished, the internal governance of the agency has been changed, and we've now appointed an agency board. The construct of it is that we've appointed 3 non-executive directors to that board through a public appointments process, and therefore we have brought more external challenge, if I put it that way, into the agency. So the 3 non-executive directors that have been appointed, one was appointed because of their background in digital IT development. Our second new non-executive director is a clinical neurologist who deals with capacity assessments in his professional life. And the third non-executive director that was appointed has come with an audit and finance background to challenge us in respect of that. In addition to that, I sit on the board. There are 4 executive members of the board, and there is a Ministry of Justice nominee that is also on the board. So we reflect now more normal agency governance, if I can put it that way, in the construct of the board.
Thank you.
We've heard in the course of taking evidence quite a number of people say that they feel that the Mental Capacity Act and the matters that flow from it are not well understood by people at large, not even by the people who might really need to and know that there are issues that they need to resolve. And I wondered about your role in raising awareness about the Act and about the necessity for compliance with it, not just amongst professionals but more widely with the general public, and what sort of information and guidance you make available for people, but also, well, I suppose it's the same question. How do people find out about you? If they're faced with a problem or an issue that might need your help and support, what's their first port of call?
Okay, well, interestingly, we've done some of our own research to find out this question, and interestingly, when we were starting to develop our digital suite of tools, we wanted to know how many of our customers actually used the internet or not. And in fact, our customer research indicated to us that the vast majority of people that are inquiring about any of our functions, one of the first places they turn to is to do a Google search. And then...
Can I just stop you? What do you think what would search term would somebody who didn't know the words public guardian, what would they put into it?
They quite often put powers of attorney in, because lots of people know about powers of attorney, or they put in mental capacity, or other ways of avenue to us is they search other well-known sites. So, okay. For instance, if they've got a relative who has dementia, they go to the Alzheimer's Society. Yeah. We have a very close working relationship with the Alzheimer's Society. They have signposting to us on their website. Similarly, we work with Age UK, who again we have a close working relationship with. We also have a very good working relationship with the CAB. Each of those 3 agencies, for instance, are going to partner with us in our assisted digital approach. So we work through a whole network of stakeholders. I've just mentioned really the charity sector. We work closely with Solicitors for the Elderly, the Law Society, similarly with accountants, representative bodies. We've done a lot of work with the British Banking Association and the Building Societies Association to raise our profile amongst the banking sector and to make sure that they have awareness of lasting powers of attorney and deputyship orders and what should do. So really I'm painting a sort of big picture of how we work through a network of stakeholders to broadcast what we do and who we are. They will signpost us and what our services are. Our relationships are good in that we sort of validate their documentation to make sure it's accurate and they're saying what we can do. Also, lots of people do seem to know that a public guardian exists because we get all sorts of queries. If you have a title public guardian, the public do seem to quite often think I can do things that I can't. But again, they'll put that in the search term to find out about us. So we have an online presence that gives information. We've also got a lot of written material about the various roles that we're responsible for, and we run a contact centre where members of the public can just ring up and we answer all sorts of queries through our contact centre, which is really busy as well.
And do you think that in relation to public information about the Mental Capacity Act and everything related to it, that it's primarily your role to be the disseminator of information, or do you think that, for example, Public Health England or any other body that has a wide range of responsibilities?
Yeah, I don't think I have got the primary responsibility for that. In fact, I've got no statutory responsibility actually to promulgate the MCA at all. That's not one of the things in the list. But clearly I take the view as public guardian, people would expect me, especially in the areas of lasting powers of attorney, deputyship orders, the supervision regime, my investigatory powers, to make sure they are well known, that people know what services we provide and how to access them. And I and my staff will take any opportunity we have to publicise them and talk about them. So I'm pleased to say that quite regularly now I'm invited to speak on Moneybox on Radio 4, for instance, and we're usually inundated with questions from the public. So there is a big demand out there to know about these issues.
Thank you.
And just ask, in all the bodies that you pointed out, you didn't point out any parts of the NHS, like medical, like memory clinics or anything. Should we attribute any significance to that or not?
No, I don't think so. I think it's fair to say that we have been responding to... We learn from the complaints that people talk to us about where they're having particular difficulties. Our mailbox and our contact centre have been inundated about complaints about how banks don't respond very favourably or recognise lasting powers of attorney or deputyship orders. So it's been one of our priorities to try and tackle that issue at sort of a headquarters level with the financial institutions to get their commitments to do something about that. We get far less complaints about NHS and those sort of services, although it's fair to say that that's sort of one of the areas that's on our list to then have a conversation with. We have very good relationships with the Department of Health and work with officials in the Department of Health to sort of raise the profile of MCA issues with professionals there. And I was at a meeting at the department recently where they were talking about how we can raise the profile. And interestingly, there was the president of the Royal College of Psychiatry, and at the end of the meeting she came up to me and asked me if I could do a one-side of A4 for doctors to explain to them what lasting powers of attorney and deputyship orders actually meant in practice. And that's something we will definitely look into and do.
Thank you.
Alice Parker, I think you've got questions 5 and 6.
Yes, I do. Do you think that LPAs are being created in sufficient number? And if they're not, what do you think are the barriers to people taking out LPAs?
Well, as I said earlier, actually we've seen phenomenal growth in the take-up of lasting powers of attorney. As public guardian, I think I'm never satisfied with the numbers that are being taken up, but just to give you a feel of the growth, in the first full year of existence of the Office of the Public Guardian, which was 2008-9, we registered just over 49,000 lasting powers of attorney. In the last complete financial year, 2012-13, we registered 228,744. So we're predicting growth rates of 20 to 25% year on year. This year, our predictions at the beginning of the business year were to register 300,000, and we're on target to exceed that. So we anticipate around May of next year on the register, we will hit the milestone of having 1 million potentially live registered instruments on the register. So the growth actually has been phenomenal, and that's been without us significantly going out and actually promoting that lasting powers of attorney are here. Part of our transformation programme in the OPG is to renew our IT systems and to give us the digital tools so that we can keep up with the demand, but also we have the ambition to have the infrastructure whereby we can go out and actually promote more, because we think there is a latent demand there that hasn't yet been tapped into. We're currently just in the process of doing, Ipsos Mori are doing a piece of research for us specifically on identifying what the barriers may be to take up of LPAs. So in other words, to give us some intelligence as to how we may tap into that latent demand. We've just had some headlines from that, and we're waiting for the detailed report back. But the indications there are that they interviewed for us a large number of people over 45, and there was a significant number of people who knew nothing about LPAs. So we need to tackle that. But when those people were told about LPAs, only a third of them thought it was something they would take up, because it's the issue of lacking capacity they felt was something that wouldn't occur to them. So I think that is a barrier that we're going to need to tackle, but it's going to be a sort of education process and getting the message out there. The reassuring thing for me is the headline piece of research is saying that those people who have had some contact with using an LPA, either through using it for a relative or knowing a relative that's needed to use it, they've actually found it to be a very empowering document, and that they are more likely to take it up because they've known someone who's used it than those people who have never had any contact with the issue at all.
Thank you. Maybe when it's possible you might give us the further details of the research. Can I just check with you one thing? You use the term 1 million live registered LPAs. Does that mean LPAs which have been triggered to come into effect, or does it just mean LPAs which have been registered?
They're LPAs that have been registered. What I mean by that is we take off, when we're notified of death or LPAs are revoked, then we take them off the register. So they are current registered LPAs, because I have no way of knowing whether they're actually being used or not.
Right. At the time when the legislation was going through, the question of knowing when an LPA had been triggered was a very considerable issue that we discussed. From what you say, that has not yet been addressed, but maybe could be by
Well, in effect,
IT
once
system?
they're registered with me, that it is a live instrument. So unless there's a restriction on the instrument that says that it's not to be used unless a trigger event takes place, a property and affairs LPA can be used straight away. So, for instance, I've given an LPA to my wife. If tomorrow I decided I didn't want to deal with the finances anymore, I could say to my wife, please deal with these issues for me and go and register my LPA with the bank. And so when I say that we don't know whether they're triggered, like mine, mine is live and could be used when it needs to be used, but at the moment I know exactly where it is, it's securely filed away, and at the moment I don't want to burden my wife with dealing with my property and finances. Clearly, the health and welfare LPAs don't come into force until there is a lack of capacity.
Right. Thank you. That then leads me on to the next question, which is, how do people who are meant to operate their LPAs know about their existence? And in particular, you referred to the banks, and the evidence that was given to the Health Select Committee suggested that while people in the upper tiers of banking are beginning to understand LPAs. Frontline staff are still not knowledgeable, comfortable about what to do on a day-to-day basis. Is that your experience?
To a certain extent, yes, but I think it's getting significantly better, if I put it that way. On the 1st of April of this year, we jointly with the British Banking Association and the Buildings Association launched a guide both for customers of banks but also for bank staff as to what to do with LPAs and with deputyship orders. Also, we have been working with certain of the large banks. When we get complaints, we take the issues up with them, not on an individual basis, but at a head office basis to see if we can resolve the issues. And many of the larger banks are now specialising and centralising their resource for dealing with LPAs and deputyship orders, so they have a specialist unit that deal with these things, and the instructions at the branch level is if you get one of these presented, ring us up and we'll give you the advice as to do with them, because the banks recognise that trying to get that detail of learning down to everybody at counter level can be quite difficult to do. So I think they're employing different techniques. We're in discussion with them now as to whether or not we can jointly develop some e-learning for bank staff, so we can disseminate that again, with the content approved by us as to what bank staff should do. And the other thing that I'm really pleased about is we've been having some early conversations with the new Finance Conduct Authority, and they've been discussing with me how they should place into their new regulatory framework the sort of issues that customers complaints to us about how banks respond can be built into that framework.
May I just follow that up in respect of LPAs that have been registered by somebody who then suffers a catastrophic event of some kind, like a stroke or an accident. You talked earlier about the anxieties that people feel about being able to access information about LPAs. I was thinking particularly about frontline medical staff, and I don't need to describe the situations in which they might need to know this, particularly obviously in respect of resuscitation. How will your new arrangements for accessing information about LPAs assist those people in feeling confident about what to do where there is an immediate need to take a decision?
Okay, well, our ambition is when we develop this, develop the online tool, is really to aid that very sort of situation. So the ideal would be is that a health professional in accident and emergency could, 24 hours a day, access the register to see whether or not there was an LPA in existence, and what that would say. Our experience quite often is the situation that A&E staff may be faced with is a relative turns up with a piece of paper and is waving a piece of paper, and they want to check quickly whether there's any validity in the piece of paper or not, and whether it's a valid instrument. And again, at the moment we have a process whereby you can do an urgent search of our register by contacting us, but at the moment we're not a 24-hour service, whereas A&E is. Whereas if we can put this online, and again what we're consulting about is whether or not care professionals like that should have an intermediate ability to search. So in other words, they have an enhanced ability to search what's on the register rather than what a general member of the public would be able to find out when they search the register. So that's the whole concept that we're looking into.
Is that because of confidentiality, or is it because they need other sort of information?
Our view is they would probably need to have slightly more detail than we would give to a general member of the public. Normally a general member of the public would only need to know, is there an instrument in existence, and where I might locate that instrument if they need it for whatever reason. Whereas for instance, a health professional may need to know the detail of, is there a health and welfare LPA, and is there a resuscitation claim linked there?
Thank you. Is the current system of creation and registration of an LPA flexible enough and responsive to respond to changes in a person's circumstances, such as the death of a donee or family breakdown? And do they have to sort of start all over again and create a new one? And could you just remind us what the cost of registering an LPA is?
Certainly. So if I take that in stages, once the instrument is made and registered with me, then it can't be altered and amended. But that's not to say that there can't be constructs within it that make it a flexible document. So, for instance, if you choose to appoint multiple attorneys on a joint and several basis, if one or other of those can no longer act, then the remaining attorneys can continue to act.
Do you add a codicil to that then, if some circumstance changes?
No, if they're appointed jointly and severally, then if any of them have to drop out for whatever reason, the remaining attorneys can continue to act. It's only if you appoint attorneys to act jointly, if one of them no longer ceases to act, then none of them can continue to act. But similarly, within an LPA, you can appoint substitute attorneys. So again, you know, if an attorney drops out, you can specify in the instrument who should take over in those circumstances. So there is that degree of flexibility in it. But also, if your circumstances do change and that you no longer want those attorneys to act, as long as you have mental capacity, then it is your right to revoke your lasting power of attorney and to take out a new one with new attorneys. And therefore, it is flexible to that extent in that you're not tied into it forever. As long as you retain the mental capacity to revoke it, you can do that. The cost of registration with me, I'm pleased to say, reduced from the 1st of October, and it is now £110 to register the instrument. So that would be £110 for property finance and a second fee for health and welfare. So if you took both out, it would be £220.
Okay.
How many people can you include in a power of attorney?
I'm trying to remember whether there isn't a limit.
There's no limit, so that you can have half a dozen of your children if you've got half a dozen children.
You could do, yes.
Thank you.
Online registration system that you're hoping to get towards, how will you fraud-proof that?
That's one of the things we're considering at the moment. So at the moment, our online tool, it assists you to complete the forms. So at the moment, you put in your details, you still have to print out the forms, you would then go and get your witnesses to sign it and you get the relevant signatures. You then come back into the tool, it will assist you to complete the registration document, you can pay online and then you can then submit it and you put it in the post to us. Again, part of us building a sustainable model to deal with the workload is when we get our new back-end system, it will just take the details from the online that when you pressed to register, so we don't have to populate our register at the back, it will automatically pull the information through. Our aim would to try and to do that completely digitally, and one of the things we're consulting about is how do we do that digitally and still maintain the safeguards, because our commitment is that it is as secure, if not more secure, by doing it online, and part of the thing we're consulting about is how we do that. So the sort of questions we're asking at the moment is if you were to register with a third-party identity assurance company and you had in effect an electronic signature that also was linked to the fact that it recognised who you were and your identity was assured, then do you need wet signatures of a witness to go alongside that, or could you dispense with those wet signatures? We would still maintain the certificate provider, because the certificate provider similarly can have an assured ID and can do that part of the process electronically, and the attorneys can also have identity assurance electronically. The interesting thing at the moment is in the current system, we don't actually do ID assurance to that sort of level. So to a certain extent, that would be more secure in the case of the ID assurance, but I know lots of people have comfort in a wet signature witness, and we're asking the question, well, does that give you as much comfort as you really think it does? Again, some of our experience would be you pop into the neighbour and say, please sign this, and we're actually wondering whether digitally we can actually design a system that may actually add more safeguards as to what's going on in the system. But we're exploring it, but the commitment from us is we want to be assured that it is as secure, if not more secure, than the present paper-based system.
Thank you.
So not simply that the witness isn't expected to know the content of the document. The witness is only confirming the signature, isn't it?
Exactly.
Yes.
Exactly.
Yes. Lord Fox?
Yes, I'd like to turn to supervision and investigation, please. You told us that you're conducting a fundamental review, I think, at the moment. And you also told us there's an increase, I think you said 8% year on year, with those who are potentially reviewable, as it were, by you. You're going to be asked in due course about how you identify questions of fraud and possible cases of fraud. I'd like to ask you, please, first of all, what role do you see yourself having in terms of supporting the skills and decision-making of attorneys and deputies? And in particular, in terms of the cost that costs are incurred by them. And I should declare an interest as a barrister that does quite a few cases about serious brain injuries. And I have seen something of an arms race in solicitors describing how much it is going to cost for them to act as a deputy for someone who has perhaps quite a large sum of money, taking decisions on a very regular basis, which they justify on the basis that the Mental Capacity Act says that it is a matter of specific decision. Every action is specific. And very often I get the impression, I'd like your comments, please, that the best and the most experienced solicitors who act as deputies are the ones who enable decisions to be made without interfering all the time. By contrast, those who feel it's necessary to ask almost and to be involved in almost every decision are charging large sums of money and therefore have a particular role in escalating the costs. Sorry, it's a long question, but I'd welcome your input.
Okay, so if I just stick on what we do to assist
Yes.
Attorneys and deputies in the first instance, in some ways I'm quite pleased that I don't have any supervisory responsibility for attorneys. I think with the numbers that we're dealing with, it would be virtually an impossible task. So as far as attorneys are concerned, we issue guidance to them about what their role incurs. We give them guidance about the principles of the Act, what they're signing up to, and so in effect they get written guidance from us. They have online guidance from us, and any attorney can ring up our contact centre and ask for guidance if they need specific guidance in a particular case. We also issue what I call practice notes. So I've recently issued practice notes about gifting. Attorneys and deputies get themselves into all sorts of muddles about what they can and cannot gift. So I've recently reviewed guidance about gifting, and that's been issued. As far as deputies are concerned, clearly I have a supervisory function in that. And as far as lay deputies are concerned, now for around the last 12 months, all lay deputies are actually contacted by us within 8 weeks of their appointment. We allow them to be appointed. They normally get notified and get the order within 6 weeks. We allow 6 weeks to settle, and then we contact them. We contact them by telephone, and we have a conversation with all lay appointed deputies to actually set the scene for who we are, what we do, but we also ask them about how they're getting on with their order. Are they comfortable with the order? Do they understand the responsibilities that the order places on them? How are they planning to deal with P's assets? Are there some big decisions over the next year that need to be made? How are they going to deal with that? And we sort of guide them through the process. as part of the supervision review, one of the things that is coming out of it is we clearly have a view that the first 12 months of appointment, whether they be a new professional who's never acted as a deputy before or a layperson, is essential to guide people to get them into the right behaviours to manage that order thereafter. So we're actually, as part of the review, reviewing as to what our interventions will be in that first 12 months to support them with that process. And then, of course, we have a process of reporting to us. Every deputy fills in an annual report to us, and on part of that process, we ask them how they have involved P as appropriate in the decision-making process during that year. Again, our ambitions, and we're developing a digital tool. Our ambition would be, in the not-too-distant future, to have a secure online account for every deputy, who then will transact with us electronically, if they so wish, through that electronic route. And in particular, I would want professionals to deal with us through that electronic route, because it's far straightforward, more cost-effective mechanism to communicate with us and deal with us in that way. Your question about professionals and the involvement of P in decision making, my experience would be it varies considerably depending on a case-by-case basis, and really depends on the level of capacity of P, if I put it that way.
But that states the problem with respect. What I want to know is whether you're, in supervising deputies insofar as you can, have any kind of advisory role or control of the costs they incur. I mean, we've been provided with the hearing before the Justice Committee in 2010, where Mr. Thompson and Mr. John described some of the fees of £409 per hour for relatively small decisions being taken. I'm wondering whether you feel it's your role to exercise some control over this sort of costs.
At the current moment, I have limited involvement in those costs, because the costs of professionals are controlled by a practice direction issued by the Court of Protection. Under the practice direction, professionals can claim either a fixed fee, or if they want to go beyond the fixed fee, they apply to the senior cost office to have their bill taxed. But as part of the review of supervision, we have been asking ourselves the question what involvement we should be having on monitoring professional fees. And in fact, only last week we had a stakeholder group of representatives of professional deputies and the representative bodies of the legal profession to actually, part of that conversation was about what role did they think it was legitimate to have in that. And we made some good progress in that sort of the view was that it's the cost office role to actually tax the detail once they've been incurred, but the view was that proportionality might be an area that the public guardian could get into, and that is an area that I'm exploring and I'm very interested to get involved with.
Thank you.
I wondered how long it would take a lay deputy to complete an annual report. Do you have any idea? I mean, how lengthy is a report?
It's not that lengthy, and again, why I hesitate, it depends very much on the circumstances of the estates that they're looking after and how complex it is. So at the one extreme, if the assets are small, and the basic question for the lay deputy is, am I ensuring that P is getting all the benefits that they're entitled to? The form can be fairly straightforward to fill in that they would fill in what the income, it's basically income and outgoings, and they summarise the key decisions that they've made during the year. Again, our ambition is to have this online account that again will have interactive tools that would assist the lay deputy and also enable any deputy, if they wished, to fill in the details as they were going along. So one of the things we do find is that quite a lot of people expect, like your tax return, they wait till the end of the year, they know the annual report is coming, and then they think about, goodness, where are the receipts, what have I done, how can I get this all together? Whereas if we can have a more interactive relationship with people, and also we make a tool that's very easy for people to use, then they can jot down things on their tool as they go along, and then they can just press the button for submit when it comes to the annual report being submitted.
Thank you. This is the question on the floor. How much of an issue is it actually for you, and how do you identify it? And in your fundamental review, when you're looking for a sustainable model, will you be actually factoring in better ways of dealing with it, or different ways?
Well, the answer to the latter question is definitely yes, but if I give you a bit more detail than the yes. So, identifying fraud, again, we have to distinguish between attorneys and deputies in this model. For both attorneys and deputies, the main way we get alerted to a concern is through some form of whistleblowing. We have a published whistleblowing line that people can ring us up, but we will take referrals on concerns through any avenue. So it could be telephone call to our contact centre, it could be a letter written in, it could be for quite a few people now email us about concerns that they have, and we get concerns flagged to us from all sorts of people. So it may be a concerned family member, it could be a neighbour, it could be a social worker. Quite often now it is banks that see some strange transaction occurring on an account, and they will flag an issue to us that they have concern. The second area for us, for deputies, is through supervision. So we have this ongoing supervision regime with them, and we will pick up things through supervision that will raise us from concerns. So there will be straightforward things. So the annual report may show a discrepancy on balances from year to year that we pick up, because they have to give us a sort of closing and starting balance year to year. They quite often will disclose unusual payments in the gifting box about what they've been spending money on. We will look at expenses, because not only do professionals claim expenses, sometimes there are quite strange expenses that are claimed, so we'll pick things up from that. We also have a trigger, is that if our fees aren't paid, or the bond fee isn't paid, or that the report is significantly late, that can be a trigger to us to have a concern. So our investigations may start either through an external referral to us or through something in our internal process. Our hope is that, well, our aim is, it's more definite than a hope, with the development of new back office case management systems and the new digital tools, to make this as robust as possible. We want to have as many automated flags for caseworkers as possible. So our new IT system should be able to identify gifting of a certain level that will raise a flag to a caseworker, because you can imagine, as we've got 48,000 of these cases to monitor, as many flags that can draw something to the attention of a caseworker that there's a concern as possible. Our biggest ambition, I'm not saying how quickly we can achieve this, is that with our secure online account, when we've developed it, that we can be as swift as the banks. So I don't know whether you've ever had the experience that I have, that when you've made a large payment on the internet, the phone goes within half an hour and the bank says, was it you that actually made that payment? My ambition would be to have an online account that if something was put on in real time that was of a large value, a flag would happen to a caseworker. They could then ring up a deputy and say, we see this transaction has gone through, would you like to explain that?
In terms of volume, very quickly, you've got 48,000 cases, and it's obviously likely to grow exponentially. In terms of capacity, what proportion of that 48,000, for example, have you had to investigate? And how, I mean, your capacity challenge is not obviously going to be met simply by digitalisation. It's going to be met by people and bodies actually on the ground.
And smart ways of working to make sure we identify what those triggers are, to identify what are the cases we should be looking at. At the moment, I'm very pleased to say that if you think that we're supervising 48,000 orders, and we've got currently, I think it's around 880,000 LPAs on the register. Last full financial year, we did 718 investigations. We have far higher than that safeguarding referrals to us, but again that comes back to having a description public guardian. We get a lot of safeguarding referrals to us that I have not got jurisdiction to look into. That's not that we ignore those safeguarding referrals, but we would signpost those referrals to other agencies, usually adult social services, that are the lead agency in dealing with the issue that's been raised with us. So I often say when I'm out publicly speaking about the office and about whether or not LPAs and deputyship orders are successful, while it is a disaster for anybody when it goes wrong, if you weigh up, we did 718 investigations out of those large numbers. Actually, the vast majority, that's saying to me that the vast majority of LPAs are working well, and that deputyship orders are working as the court intended them to work in the first instant. That's not that I'm complacent about that at all, and I'm very hot on that we have to be strict on those issues, but I think those numbers put it in proportion. And of those 718, a significant number of those we would have investigated and found there was no cause for concern.
In evidence to the Health Select Committee in 2010, your predecessor suggested that the lack of power to compel third parties to provide financial information could create delays in investigation. He also suggested that the power to delay registration of an LPA pending an investigation into concerns would assist your role. Are these still concerns, and has there been action to remedy these?
Yes, I would say from my position they are both still concerns. There has been no movement on me having statutory access to financial records, so I have financial access to your health records and to your social care records, but I have no access to P's financial records under the statute. And so both of those issues are still outstanding. What I would say is that we now have an agreement and are working with policy colleagues within the Ministry of Justice to actually work up a policy solution to those areas, and we're looking for the opportunity to find a legislative slot to do something about both of those matters when that occurs. So we've now got commitment from the department that that is an issue, and to work on that. I would also say that we've also got agreement with policy colleagues that now, having had 6 years of experience of working with the powers as defined under the Act, there are other areas sort of around the margins of my powers that we would like either extended or tidied up, if I put it that way, to assist in that safeguarding role. And again, there's agreement that we will be working up those areas, and again seeking the necessary legislative capability to be able to do something about those as well.
Have you actually got any legislation drafted?
Not at the moment, no. I've just got the agreement with policy colleagues that can be worked up and looked at, so we will be working up those propositions and then looking for the legislative opportunity to deal with them.
Thank you.
You say you've just got agreement with policy colleagues. When was that reached, this agreement? When did you get this agreement?
We've been in discussions with them shortly after I came into post, and probably the agreement to actually work them up, it's probably been within the last 6 months.
Okay. Thank you very much, Mr. Eccles, for your useful evidence. We're very grateful to you for coming along today. And that's the end of this formal session.
Thank you.
committee